Thank you, Raghav. I hope I'm audible. If I think I am.
Sir, you're audible, मगर आपकी आवाज थोड़ी कम आ रही है पहले से.
अभी better है?
Yes, much better.
All right. Okay. Very good evening, all. I know it's late at night. I'll not take much time. And Raghav, thank you for the fabulous session. It was very informative. And as far as I go, I will not be able to focus so much on the sections, and I won't know them. So I'll only focus on the practical side of the codes. And to begin with, I mostly deal with criminal cases. I'm a little weak on the civil side, so pardon me if I fumble a bit on your questions on the civil side. All right, I'll answer what Mr. Rishipal Singh asked. As he said, there was a diary, and despite his objection, the court agreed and marked the pages in the diary. Is that correct, sir? That's what you're saying?
Yes, sir. Yes, sir.
All right. So technically, the difference between marked documents and exhibit documents is exhibit, it means it's admitted, and the court is going to rely on the that particular document. Okay,
That's right.
Admitted for sure. Marked means it has a probative value. The court, it's the discretion of the court. It's only going to corroborate your other evidences. So it is not admitted. So if it's only going to circumstantially say, oh, look, okay, there is this document, or there was this poster which was circulated in the city. You cannot exhibit it because it was just a poster which was being circulated in the city. So it will have a probative or corroborative value to your case. It is not an admitted document. So you clearly sideline that piece of paper. So when we are tendering the documents, we say either it's marked or it's exhibited. So for instance, I have the original copy. I want to exhibit my report card of the school, or I want to exhibit my bank statement in a particular case. What I'm going to do is I'm going to get an original bank statement passbook, or I'm going to get a certified copy of my bank statement from the bank which has issued me that bank statement. Only in that circumstance that bank statement will become an exhibit. And the court is going to write exhibit PW1/1, PW1/2, whatever it is going to write, or respondent witness 1/34556, whatever number I'm going to give to that document. If that document is not a certified copy, or you do not have an original to produce, for instance, I'm producing my passport copy into the court. Look, I was traveling to United States on so and so date. For instance, I want to submit that document for my alibi. In that condition, I might have a photocopy at the time of my evidence in chief or cross-examination, but I should and must have an original passport in order to exhibit that particular photocopy page in the evidence. Otherwise, the court is not going to believe that I ever traveled to United States. And even if I want to further strengthen my evidence, I will call immigration officer to certify that stamp on that particular piece of passport, because if I do not call him, the court or the other party could object, look, it could be a fake stamp. How do I know that he actually traveled from Delhi immigration? All right. So in order for me to further strengthen my evidence, I'm going to issue notice to the immigration department, IGI airport, Ministry of External Affairs, whosoever is responsible, whosoever can certify that stamp, I'm going to call them. Then only that particular evidence is going to be accepted in court of law that yes, this guy traveled from this state to this state. All right. Otherwise, the other party could object. Look, I don't agree to this stamp on his passport. You need to get it authenticated. So this is how. What is the difference between mark and exhibit? So mark has technically zero value in the cases. Okay, you could only be substantiating your argument based on those pieces of papers. Look, this is what circulating, or I wrote a diary, or I published this, or I did that, so on and so forth. All right. So the reason Raghav has called me is basically to discuss some practicalities in the court insofar as evidence in chief and cross-examination is concerned. I'm going to mostly stick to the cross-examination in a sessions court, and where it happens seriously and on day-to-day basis. All right. So I'll begin with the question of the sequence of witnesses examined. Now, it's a very important question because, for instance, if it's a rape case or it's a POXO case or any of those heinous offenses, the prosecutrix or the victim on who the rape has been committed is the most important witness. Okay. So just based on her statement, a man could go into jail for 20 years just because on her statement. If there is no medical evidence, there is no DNA, there is no blah, 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 no noise. The jurisprudence, the judgments have actually gone too much into favor of women. So now she is your most important witness, the victim or the prosecutrix, we call it. So the importance in for the series of sequence of examination is generally these are called vulnerable witnesses. Okay, vulnerable witnesses are the eyewitnesses or the witnesses who have actually experienced the assault. So if I have been hammered or beaten by a bunch of guys, I would be a vulnerable witness. If I've been raped, I'll be a vulnerable witness. If I'm the father of the deceased, the person who died by goons, I'll be the vulnerable witness because I've seen or experienced that thing. All right. And I'm the only person who could be intimidated by the accused. Now, what happens in the heinous offenses if the accused are generally not released on bail? For 90 days, they're in bail for sure. And police is smart enough to file the charge sheet before 90 days. So it's a very rare scenario where you are entitled for the default bail. It doesn't happen every day. Okay. They have their timetable sorted. They'll file whatever nonsense charge sheet they'll file and you'll be tried. Thereafter, what happens? The prosecution, people apply bail, they apply bail within those 90 days, they apply bail for after that. But courts do not grant you bail until unless prima facie the case is absurd. Okay? Or you've been made accused just out of fun. The main accused, for instance, the rapist, the accused rapist, he will only be considered for bail in 99% of the cases once the vulnerable witness has been examined. And the most important vulnerable witness is the prosecutrix or the victim or the minor girl. So that is, as a defense lawyer or in the interest of the justice, court decides they will be summoning the vulnerable witnesses in the first instance. So the family of the prosecutrix will be summoned first. It's the girl who's going to be examined, then the father or the mother or the brother, sister, whosoever is there. They'll call everybody on the first date. As a practice, all the vulnerable witnesses are examined one after the other. Why they are examined one after the other? Because if me as a girl, I'll know what questions I'll be asked, right? And the second important witness is my father or my mother. So I'll go home and I'll teach her whatever I've been asked. So the next time the mother will come prepared. So in such cases, all the vulnerable witnesses are called in one day. In-camera proceedings happen mostly if it's a woman. And one after the other, the defense lawyer and the public prosecutor will be asked to examine the witnesses at a stretch. It gets very hectic, but it is very, very, very important. All right. Another interesting things happen in the practical life is, as Raghav has already discussed this fact, the witness should not sit in the court. If you are allowing the witness to sit in the court, the first objection you make at that point in time is, Your Honor, PW2 is sitting in the court. I'll not move ahead with my cross-examination. Okay. The judge will ask the PW2 to go outside, sit. Okay, this is what happens in the practice. The point that, okay, the witness is sitting and then you propose to the Your Honor, you know what, the second witness is sitting in the court, please address this point in my cross-examination. They'll not do that because it comes on them. They wouldn't want to write such things that, okay, I was so reluctant about, I don't know what's going on in my court, because it's the duty of the judge to know that where the witnesses are sitting. So they're not going to actually write in the cross-examination that the second witness is sitting in the courtroom or the third witness is sitting in the courtroom while the cross-examination is going on. You need to be proactive and you need to ask the judge then and there, but please clear them off. I will not proceed ahead with my cross-examination till the time these vulnerable witnesses step out of the room. That's a very, very important thing. Okay, nobody should hear your questions, what you're asking. Now, the third thing, what is very important in real life is, for instance, you start doing your cross-examination. The cross-examination stretches post-lunch. It's already 1 o'clock. Like some courts, the lunch starts at 1. Some courts lunch starts at 1:30. They will defer the cross-examination, but make sure that your witness does not go out for lunch. Because there is a defense lawyer, there is a complainant's lawyer, PP is not going to take much interest. But there's always a private lawyer next to the aggrieved party, all right, who is going to be assisting the who's going to assist the PP. So there'll always be a private lawyer in these heinous offenses if the party can afford. So he's observing the entire evidence in chief and cross-examination. The moment you allow the witness to go for a lunch, he's going to tutor the witness. So if the lunch break happens, you stay in the courtroom and the witness also stays in the courtroom. So somebody asked me a question on the chat that how will we stop them? You tell the witness, you tell the judge, Your Honor, she's not going out of the room. I want this witness to stay in the room. So you confine the witness in the courtroom. She's not allowed to leave. And the judge understands that. Okay, the judge will only tell that she's not going to leave. वकील साहब आप जाके अपना खाना वाना खा के आओ, तो वो पुलिस की निगरानी में अंदर ही बैठी रहती हैं जब तक उनका पूरा क्रॉस एग्जामिनेशन नहीं होता था. That's a practice, because these, always remember, these heinous crimes, murder, rapes, punishment could be 20 years. And all you have as a defense lawyer is 1 day. 1 day to make or break your case. So if you're not prepared, or if you goof up or you do stupid things in the cross-examination, it could just break your case, and somebody's entire life is in your hands, telling you it's a very serious job. So you can't have lapses there. So this is another practical tip. A lot of lawyers take it for relaxation, or they go out and they start the lawyers start calling the witnesses inside and they speak. You can even monitor that, because for that particular 2 or 3 hours, the witness is in your custody. She's your witness. Now, another second thing, practical thing, what happens when you are cross-examining is the interruption of the private counsel or the public prosecutor while the witness is answering. Do not allow that to happen. Okay, you can have a serious objection to that. If you hear an answer, murmur, and the private counsel of the victim interjects or answers your question, you can ask the judge to make him sit at a distance, and the judge will do that. It's a very big no-no. You can't allow that to happen. Like, for instance, I was asking a question that what number did you dial to call the police? So this particular victim happens to get hold of the mobile phone of the accused while she was in confinement. She calls the police, and she was stressing on the fact that I called Mahila police. And I asked her, what number did you call? And she says 198 or something. Okay, she said 198. And very quickly, the private counsel who interject and say 1098. Okay, and this was a very important question for me, because if she's claiming that I had called the police and police came to rescue me, then you should know the number. And on a general wisdom or prudence person, not many people actually know the number of the Mahila police. You would know 100, you know 112, but ये जो महिला पुलिस वाला number था, ये आम आदमी को नहीं पता, and somebody who's a minor child of 13-14 years, it will not even appear to her. So definitely it was tutored and she was told at a later stage. मुझे आज तक नहीं पता कि महिला पुलिस का फोन नंबर क्या होता है. So it was a very important question, and the judge interjected, and she actually got wrote it down 198 what she had actually spoken, because it's very important contradiction. So now going, this is how things actually happen in a courtroom. So you have to take a strong resistance to whatever you're asking and what kind of replies are you getting. Okay, so going back,
sir,
yes,
I'll stop you here, sir. Anju का कुछ question था, if we can take it.
where is Anju?
Hi, I had a certain question regarding the witnesses that you were mentioning. I understand that it is very easy to prime a witness, which is why all these protocols, etc., are maintained. That while you are, asking one witness, the other one has to leave the court, etc. But then, how do we curb the electronic media from transferring information? Like, for example, if I'm sitting in court and I have my phone on, or even if there is an advocate, he could have his mobile on, and the person sitting or standing outside can easily listen to the whole conversation.
That is definitely possible. You can, generally lawyers don't do that, and there is nobody else, so you can ask that person to remove the phone and put it on the side if you want to.
But
you can take as many precautions in the courtroom you want to.
What my question really was that, is it a matter of a standard practice that advocates take these precautions?
See, you would know what is happening and what is not happening. So generally, depending on the client, depending on the kind of socioeconomic background that person is coming from, you could know that something fishy is happening, or the cross-examination is being transmitted, so on and so forth. It doesn't happen that often, but as a precaution, if you're really concerned, you can always ask them to put their phone on the side.
Okay.
You can. Judge will not object to it. Does that answer your question?
Yes, very much.
See, of course, you're not collecting evidences at the point in time, but you need to be, as a practice, you need to make sure that you're not out and loud there, that the entire world knows what you're talking about. And even if you are listening to what has been answered, what is being transcribed into the computer is a different statement altogether. Okay, so it's not that easy for the person who's sitting outside and listening to comprehend exactly what is going on. But yes, this could happen. People are smart. They carry phones and wires, and they go for examination. If you're caught, you're screwed. If you're not caught, then you had your day. So, but as a defense lawyer, you can definitely take an objection to it, and the judge will agree.
Okay, but
All right.
not like when you talk about a high-profile case where everything could be extremely crucial. Like when you mentioned that when it comes to criminal cases, one has to be extremely cautious. Then is there a protocol wherein whosoever enters the court, their phones or any electronic gadgets are confiscated?
See, ideally, it's written everywhere that your phone should be switched off. Okay, lawyers don't switch it off. They have to check the calendars, they have to check the dates, they might have to take urgent calls, but you can insist for the litigant to switch off their phone as a protocol, because there is a poster everywhere in the court. People don't do it. I mean, now you've insisted so much that I might start doing it next time. But we generally stick to the fact that the other witness should not be in the close vicinity. And the other thing what happens is, Anju, they do not have so much of time to discuss with the lawyer, because the private counsel is actually standing next to the witness who's been examined, and the second witness will be examined next moment. So they do not have the time to interact. It's only the lawyer or the counsel who's going to actually explain you what to say and what not. So you do not give that amount of time for them to go and get tutored. A normal litigant, until unless you are a pro or you've been dealing with a lot of cases, you will not understand what has happened inside. So there are a lot of bottlenecks which would actually not allow this to happen. But yes, as for to be really on the safe side, you can always ask the litigant to the witness to switch off the mobile phone and the pause it. No one is going to disagree.
Coming out of an observation which I made in High Court, wherein everybody had their laptops on, and despite the fact that of course you can't put your earphones on, which are visible to the eye, but everybody pretty much in a civil suit was handy on their laptop and on their
Yes, because in high courts and Supreme Courts, everything is digitized and no evidence is recorded in the High Court. So there are no physical files anymore in the High Courts. It's a Foxit Reader PDF which is bookmarked, and you're going to put your laptop and tell the judge lordship item number 15, bookmark number this, bookmark number that. That's how they go. So evidences are not recorded there. So electronic gadgets are being used left, right, and center. That's a new way of arguing in the High Courts.
But that's not the case in a criminal court, is it? Like,
No. Criminal courts, you don't use any electronic devices. Everything happens on the computer of the stenographer who records your evidence. But if there is a digital evidence which you're going to use, then yes, you're going to put your laptop on or tablet on in order to show the video to the witness. Yeah. All right. Shall I move ahead?
Yes.
Okay, I forgot what I was saying before. Okay, never mind. So we go back to the, I've spoken about the sequence of witnesses, the way it should be examined. I've spoken about the what precautions you should take, and Anju definitely supplanted my idea and increased my horizons. Next time I'm going to be more cautious. And thereafter, I'm going to speak about the sequence, what happens in the court and how the examination in chief happens. All right. I'm going to quickly share a screen for you to understand how the evidence is recorded. How do I share screen? You need to allow me.
You have the access now, sir.
I do. Okay. Okay. Can you see the screen?
Yes, sir, we can.
All right. I would prefer if more people can put the video on. I understand what frustration Raghav goes through. All right. So this is a cross-examination. I've obviously hidden the which court it is and who are the persons accused and victim and blah, blah, blah. So you'll only see the alphabets. I cannot disclose you those details. So this is state versus 1, 2, 3, 4. There are 4 accused in this case. All right. And this is the name of the judge, so on and so forth. Now you see the statement recorded in camera. Why do you see the typed version? Because this particular statement was used in High Court for the bail application. So we need to have a true type copy in case the version is not, you cannot comprehend the original copy. Now, as a protocol in POCSO cases, the judge is supposed to assess the mental capacity of the minor child. So it could be a minor child of 7 years, it could be 10 years, 12 years, 14, 16, so on and so forth. All right. So the judge technically evaluates the capacity of the minor child, that is she actually in position to depose, because this cross-examination can really go haywire. And I need to assess if the child isn't actually in position to answer the question what the defense lawyer is going to ask. Now, so as a protocol, they generally ask them, they make them comfortable. They ask them questions. What's your name? What do you like to eat? So on and so forth, so that the child gets a little comfortable in the court surroundings. So you see these questions: in which class, in which school are you studying? I studied up to 2nd class. what do you like to eat? I like to eat aloo parathas. What are you fond of? So on. These are very standard questions. So the judge actually makes the child sit next to her and ask such questions, and the camera proceeding happens. Now, if the judge gives a verdict that okay, this particular witness is okay to be examined by the defense lawyer, then only the child goes further with the defense examination chief by the PP and the cross examination by the defense lawyer. If the judge feels that it should all happen in her supervision, or she should be the one to put the questions what is appropriate, then the judge has the discretion to do so. You can't really object. Okay. So after this initial assessment, she's written. I have put general questions to the witness, and I'm satisfied that she's in fit condition to depose on oath as a competent witness. So she's declared this witness as a competent witness. Now, this is her. At this point, the public prosecutor will start asking her questions. Tell me. So the file will be with him, and he's going to start asking questions. He would have actually, it's not a joke. A public prosecutor deals with, in a sessions trial, 10 to 15 cases every day. All right. It's a different thing how many witnesses are examined. So he's not a superhuman being. He won't even remember the case of your facts. He's least bothered. Okay. It's not an easy job, I must say. He's only going to pull up the file. He's going to read your 3 statements. 164 CrPC statement, which happens in front of the magistrate. Legal aid statement or child welfare committee statement. These are 3 protocols statements which happens in front of legal aid, in front of police and child welfare committee. I'm talking about the POCSO case. Now, if it's a murder trial, it is only going to be a statement in front of the police. You're not going to magistrate to give any statements. But in certain cases, like POCSO 354 rape cases, there's something called 164 CrPC statement. Okay. Is everybody aware of 164 CrPC?
Yes, sir.
All right. I'll just quickly tell you what 164 CrPC is. Anybody wants to help me?
Should I read, sir?
Yes, please. I mean, just very briefly. It's going to take a lot of time. I'm just telling you what it is. Recording of confession and statements. Okay, any metropolitan magistrate, judicial magistrate, whether or not he has a jurisdiction in case, record any confession or statement made to him in the course of an investigation under this chapter or under any other law for the time being in force or at any other time afterwards before the commencement of an inquiry or trial. Now, what is important is there is a proviso which is given after point number 5. In cases punishable under section 354, 354A, 354B, C, D, 376 series, 509 of IPC, so on and so forth, the judicial magistrate shall record the statement of the person against whom such offense has been committed. So if you're aware of these IPC sections 354 and 376 series along with POCSO, they're all women-centric sections. And they're all considered in sort of a heinous offense category. All right. So it is incumbent, it is mandatory on the police to take the victim to magistrate, judicial magistrate, and get the statement under 164 recorded. It is like a statement getting recorded on oath. अब क्यों ये important है? ये इसलिए important है क्योंकि magistrate आप पुलिस के सामने झूठ बोल सकते हो, आप लीगल एड वाले के सामने झूठ बोल सकते हो, आप यहाँ चाइल्ड वेलफेयर कमेटी के सामने झूठ बोल सकते हो, इन्फ्लुएंस कर सकते हो, सब कुछ कर सकते हो. दे आर नॉट कोड ऑफ लॉ. बट मैजिस्ट्रेट के सामने आप अकेले होंगे, ना तो वहाँ पुलिस है, ना आपके वहाँ पेरेंट्स हैं, ना आपको वहाँ कोई इन्फ्लुएंस करने वाला है. मैजिस्ट्रेट डेफिनेटली डज नॉट हैव एनी वेस्टेड इंटरेस्ट इन दिस केस. शी इज अ जज. So when you're recording the statement in front of the magistrate, the quality of that statement is pretty decent. It is like I'm giving my preliminary evidence on oath. That is the probative value of 164 CrPC statement. I hope I'm not digressing too much, but I think it's a practical tip for all of us to know. So the chances of now, how do you damage this 164 statement? Definitely the prosecution and the parents and the lawyer of the victim and the police, they tutor the person, okay, this is what you're going to tell inside. All right. Sometimes witnesses actually tell the truth. No, you know what? I was in love with this man and I ran away on my own. My parents did not allow me to get him married. वो ये statement भी दे सकती है वहाँ पे. और contradictory statement उसने पुलिस के सामने दी होगी under the pressure of the parents. So maybe the parents dictated the statement and the victim did not. So the police has a very important role to play in these cases because it's a very good money-making opportunity for the police. Any women-centric case, be it 498s or rapes or POCSO, it's a very good money-making opportunity for the police. So they definitely would want to file a charge sheet. They would want to blackmail the accused or his family to either settle the matter or, you know, exchange money at their hands, so on and so forth. It's a very big, that's a topic for some other day. But and police can make you write anything. So the value of the statement of the police in the court of law is technically zero. Okay, so they're going to ask you to write a disclosure statement. Accused की कनपट्टी पे बंदूक रख के वो बोलेंगे कि तू ये लिख या उसे साइन करा लेंगे, कुछ भी लिखेंगे, ठीक है. और यही प्रोसिक्यूटर्स की भी स्टेटमेंट वो कुछ भी लिखेंगे. So it technically has a zero value. Now the fun part is when the evidence in chief starts in the court, the public prosecutor is going to ask you, ask the witness or the victim, tell me what happened with you. तो वो एक बारी उन्होंने ब्रीफली केस पढ़ लिया रहेगा 164 से CWC से लीगल एड की स्टेटमेंट से, एंड देन शी इज गोइंग टू स्टार्ट टेलिंग. अब जैसे इस केस में क्या हुआ, I've studied up to second class. We are 3 brothers, sisters. On 25-21, 1K along with her sister J and her daughter S came to our house. All the people gave me beatings, pressurized me to marry S. Otherwise, they'll kill my parents. Thereafter, the accused took me to Dash bus stand and they made me sit in a bus and took me to Dash. Then S, P, K, R and N took me to so on and so forth. Then they took me to so on and so forth. We stayed in a hotel for 1.5 days. In the hotel room, S, N, R committed rape upon me. Thereafter, all the people took me to Dash. All the accused thereafter took me to village Dash. In the native village of P, we stayed there for 5 to 6 days. P sold me on every night that I stayed with her in village XXX. I was raped by boys to whom I was sold. I tried to escape from the house of the P, met boy R and requested him that I wanted to go back to my house. R called up my parents. My parents came to take me from N, from P's house. They brought me to the house in Dash. I told the entire incident to my parents. It's very complicated, I know. But to reiterate the facts, what had happened is, initially, in her initial statements, the victim had said that इसकी मेरे पड़ोसी की मौसी की लड़की मुझको फलाने फलाने बस स्टैंड तक ले गई, वहां मेरे को बस में बिठा के हम फलानी सिटी पे गए, हम इस सिटी में एक फलानी औरत से मिले, वो फलानी औरत हमको राजस्थान के किसी शहर में ले गई, वहां पे हमने शादी वादी अटेंड करी, वहां से हम यूपी के दूसरे शहर में चले गए, यूपी के दूसरे शहर में मैंने होली खेली, मैंने सब कुछ किया, उसके बाद वो मेरे को हर रोज बेच देती थी, फिर मैं वहां से भाग गई और फिर मेरे को एक भैया मिले, भैया से फोन लेके मैंने अपने पिताजी को फोन किया और पिताजी मुझको पुलिस के साथ आके वापस ले आए अपने शहर. So she was actually on a 10 days voyage to everywhere in India. और इस voyage में in the process the neighbors were impleaded और neighbors का कुछ लेना देना नहीं था. तो क्या हुआ, जब एफआईआर लिखी गई तो 5 दिन बाद पिताजी जो थे, वो पिताजी के दोस्तों ने बताया कि अरे मैंने तो इसके साथ जाते देखा था, मैंने उसके साथ जाते देखा था, सो ऑन एंड सो फोर्थ। तो पड़ोसन को भी पुलिस ने अरेस्ट किया, पड़ोसन के हस्बैंड को भी किया, उसके भाई को भी किया, सबको अरेस्ट कर चुके थे। बाय द गर्ल वाज ऑलरेडी रोमिंग अराउंड इन रेस्ट ऑफ द इंडिया. She meets different people. Now she is giving 3 different statements in her 164 CWC and legal aid statement, all 3 different versions. Okay. अब 1-1.5 साल बाद एविडेंस इन चीफ आता है, तो इनिशियल वर्जन में तो ये तीनों लोग उसके साथ नहीं थे। इवेंचुअल वर्जन में क्या हुआ कि ये तीनों लोग भी उसके साथ अकंपनी कर गए, एंड the entire evidence in chief started from one man raping her to the entire world raping her now. आपने देखा उसको फलानी सिटी में 3 लोगों ने रेप किया, फिर वो यूपी के किसी शहर में चली जाती है, वहां पे ये लड़की उसको हर रोज बेच देती थी, तो शी वाज सोल्ड टू मल्टीपल पीपल. दैट्स व्हाट हर न्यू नैरेटिव वाज. एविडेंस इन चीफ चेंज हो गया. अब हमें जो क्रॉस एग्जामिनेशन करना है, हमको इस एविडेंस इन चीफ के बेसिस पे ही करना है. यहां तक एविडेंस इन चीफ हो गया. अब आप ये देखिए कि माय स्टेट, आई डू नॉट रिमेंबर हु वाज इट. My statement was recorded before Legal Aid Council, which is Exhibit P1, which bears my signature at point A. My statement was also recorded before Child Welfare Committee as Exhibit P2, which bears my signature at point A. At this stage, a sealed parcel is opened and a statement of prosecutor is recorded under section 164 CRPC is also taken out. My statement under 164 CRPC was recorded, which is exhibit P3, which bears my signature at point A. Now, what is interesting here is, folks, ये तीनों documents पे prosecution rely कर रहा है. अब जब प्रोसिक्यूशन इन 3 डॉक्यूमेंट्स पे रिलाई कर रहा है और वो क्लियरली बोल रहे हैं कि ये तीनों स्टेटमेंट्स मेरी हैं, दैट मींस आई एम अग्रीइंग टू द कंटेंट्स ऑफ दीस 3 स्टेटमेंट्स बाय वे ऑफ माय एविडेंस इन चीफ. आई एम नॉट डिनाइंग द कंटेंट्स ऑफ दीस 3. इट हैज कम इनटू द रिटन रिकॉर्डिंग दैट लुक, लीगल एड स्टेटमेंट भी मेरा है, चाइल्ड वेलफेयर कमेटी का स्टेटमेंट भी मेरा है, और 164 का भी मेरा है. हो गया यहां तक. अब ये जब इसका हो गया, इस स्टेज पे एक्यूज्ड को दिखाएंगे कि डू यू आइडेंटिफाई एक्यूज्ड, डू यू एक्चुअली नो हु दैट मैन स्टैंडिंग इन ब्लू टी-शर्ट इज. सो prosecutrix, the victim will either say yes or no. 99% they will say yes, I recognize him, he is the one who raped me. ये हो जाएगा. इसके बाद XXS by learned defense counsel, so on and so. इसके बाद क्रॉस एग्जामिनेशन शुरू हो जाता है. अब क्रॉस एग्जामिनेशन में आप क्वेश्चंस पूछना शुरू करेंगे. नाउ हियर यू आर गोइंग टू मेक और ब्रेक योर केस. दिस एविडेंस इन चीफ इज गोइंग टू एक्चुअली कॉस्ट योर क्लाइंट इज 20 years. If you screwed it up, you really screwed it up bad. If you did not, then it made your day. इसके बेस पे आपकी बेल डिसाइड होगी, इसके बेस पे आपका कन्विक्शन और एक्विटल डिसाइड होगा. अब what is important here is that do not ask questions which the prosecutrix or the private counsel of the prosecutrix has actually tutored her, or she could have an explanation to. Because if she starts explaining, that means कि वो सोच के आएंगे ये सवाल पूछा जाएगा और हमें इसका जवाब दें. वो टाइम भी डिसाइड करे होंगे, वो सब कुछ करे होंगे. मोस्टली इट्स अ मेड अप स्टोरी. तो आपको ये सेंस करना है कि किस क्वेश्चन का, एंड सी नोबडी इज अ जीनियस, समटाइम्स यू goof up because you won't know कि वो किस चीज को बहुत ज्यादा डिटेल में प्रिपेयर करके आया, किस चीज को नहीं करके आया. ठीक है, थोड़ा बहुत आपको समझ में आएगा, बट देन यू होल्ड योर हॉर्सेस. नाउ the most important tip I'm going to give during cross examination is do not have an aggressive body language. Okay. Mostly on day-to-day basis or with the busy counsels, they do not know who's against you or who's anti you or who's not. तो कई बार क्या होता है कि आप अगर बहुत ज्यादा aggressive body language दिखाते हो और उसको ऐसा दिखाते हो कि look I'm your enemy, तो उनको पता चल जाता है कि आप उनके enemy हो. ठीक है, you got to build up that rapport with your witness. The witness is your person. तो आप उनसे बड़े प्यार से बात करोगे, आप उनसे बड़े इस तरह से बात करोगे जैसे यू आर हेल्पिंग देम. Or to begin with, you can even tell them, you know what, you really need to get this right because तुम्हारी वजह से कोई 20 साल के लिए अंदर जा सकता है. तो जो बोलो वो सच बोलना, ठीक है? थोड़ा सा compassion दिखा के, थोड़ा सा प्यार दिखा के, that's when you start your cross examination. Never raise your voice. अगर वो smart बनने की कोशिश कर रहे हैं, तब भी मुस्कुराते रहो. और थोड़ी देर के बाद डिफेंस काउंसिल, जो प्राइवेट काउंसिल है, वो अगर प्रिपेयर नहीं करके लाया, उसकी बॉडी लैंग्वेज बड़ी अनईजी होने लग जाएगी ऑन योर क्वेश्चंस बिकॉज़ ही वाज नॉट एक्सपेक्टिंग यू टू क्रॉस एग्जामिन लाइक दिस. दे विल स्टार्ट क्रिएटिंग ड्रामा इन द कोर्ट. इग्नोर इट. डोंट रेज योर वॉइस. ठीक है? यू have to be calm at every point in cross examination. Can be as aggressive in the arguments, doesn't matter, but cross examination में आपको बहुत calm रहना है. अब आगे चलते हैं. अब जैसे क्वेश्चन, अब यहाँ पे जो रिकॉर्ड हो रहा है, तो यहाँ पे ये रिकॉर्ड हो रहा है डेफिनेटली आई मिस्टर वास की इट्स अ फिक्टिशियस नेम अनामिका. आप कौन सी क्लास तक पढ़ी हैं? शी सेड आई स्टडीड अप टिल सेकंड क्लास. अच्छा, अभी भी स्कूल जा रही हैं? नहीं, अब मैं स्कूल नहीं जा रही. आई एम नॉट गोइंग टू स्कूल एज आई डिड नॉट वांट टू स्टडी एनी फर्दर. आई लेफ्ट स्कूल एट 2-3 years back. फिर आप पूछोगे कि अब ये अगला सवाल था कि जो एक्यूज्ड एस और एफ है, ये आपके घर से कितनी दूरी रहते हैं? तो सीधा रिकॉर्ड होगा कि एक्यूज्ड एस वो है वॉकिंग डिस्टेंस रहते हैं और उसके मेरे घर के बीच में 2 मिनट का डिस्टेंस है. अच्छा, उसके बाद आप ये पूछोगे क्या एक्यूज नंबर दिस का घर आपके घर और बस स्टैंड तक जाते हुए रास्ते में पड़ता है? ठीक है. सो इफ यू हैव डन योर होमवर्क यू वुड नो दैट. इफ यू हैव नॉट डन योर होमवर्क यू वोंट नो दैट. तो अब उसको पता चल गया कि मेरे को सही बोलना है, झूठ बोलना है, बिकॉज द नेक्स्ट थिंग आई हैड वाज द गूगल मैप और द फोटोग्राफ्स ऑफ द रूट. ठीक है. तो उससे अगली चीज पूछेंगे कि अच्छा, अब आपने ऑटो लिया था, तो क्या इस पर्टिकुलर विटनेस का घर आपके रास्ते में पड़ता है? बिकॉज एज पर द फाइल दीस 2 witnesses have seen you going with so and so on a particular date. So she's not prepared that इसका क्या pretext है ना? उसने फाइल नहीं पढ़ी, उसको ये भी नहीं पता कि विटनेस कौन है. तो मैं उससे पूछूंगा क्या इन दोनों आदमियों का घर पड़ता है? तो बोली नहीं, उनका घर रास्ते में नहीं पड़ता है. फिर उसके बाद अच्छा, क्या आप इसकी मौसी की बेटी को जानती हो? वो बोली कि नहीं. अब I'll just bring you to the when you confront a document, so you start your cross examination like this. Ab okay, here देखिए. I met P's sister husband there and I saw no children. We left this place at 1 to 2 p.m. approximately on this date. I was almost around 7, blah blah blah. I did not sign in the hotel register. ठीक है. She says I did not sign in the hotel register. उस पॉइंट पे मैंने उसको चार्जशीट का होटल जो जिसपे प्रोसिक्यूशन रिलाई कर रहा है, मैंने उसको वही डॉक्यूमेंट दिखाया. मैंने उससे पूछा अच्छा ये बताओ ये आपके सिग्नेचर हैं? तो कहती हाँ है. So she identified her signature in the document which is actually part of the charge sheet, and anything which is part of the charge sheet means prosecution is relying on them. Up, what is interesting to note here is this: victim is confronted with exhibit B1 where signature of the victim is present. She has identified her signature at point A. अभी D1 क्यों लिखा गया यहाँ पे? Because अब ये डिफेंस का डॉक्यूमेंट बन गया, though it is part of the charge sheet. ठीक है. तो क्योंकि ये जनरल डिफेंस का है, अब इसमें ये नहीं लिखूंगा कि D1 exhibit 1 D1/1. It is the evidence of the defense. So any evidence which is confronted to the prosecution cumulatively becomes a defense evidence. It's not divided कि इसका evidence है उसका evidence है. There could be multiple accused or there could be one accused. ठीक है. तो cumulative defense evidence बन जाएगा. तो अब ये डिफेंस एविडेंस मार्क हो गया ये डॉक्यूमेंट, और उसने क्यों मार्क हो गया? क्योंकि उसने एडमिट कर लिया. अब शी वाज स्मार्ट इनफ, इफ शी वाज अ प्रोफेशनल विटनेस, she could have easily disagreed. फिर मैं कुछ नहीं कर सकता था। वो बोल सकती थी कि मेरा तो नहीं है, मैं तो नहीं जानती। For you to get that kind of competency in the court of law, you need to be an expert witness, or you need to have actually faced a lot of trials. So for her, this was the first trial, and she jolly well jumped and said, yeah, मेरे sign, मैंने ये, तो खुश हो गई। समझ रहे हो? तो मेरे को पॉइंट मिल गया कि उसको कन्फ्रंट कैसे करना है। मेरा फर्स्ट एविडेंस बन गया कि तूने होटल के रजिस्टर में साइन किए थे। दैट मीन्स your presence has been marked there, and in your previous statement you have said, no, I did not sign anything, I did not sign in the hotel register. That means you're hiding something. It's a minor contradiction, but it says a lot. अब यहां देखिए, मैंने उससे पूछा कि I have stated in all my 3 statements that R, N, and S committed rape upon me in XXX city. Confronted with the victim with all the 3 statements, which is exhibit P1 to exhibit P2. If you remember what had happened in the evidence in chief, these 3 were exhibits of the state, exhibit of the prosecutrix, correct? अब मैं उसी की स्टेटमेंट से उसको कन्फ्रंट कर रहा हूं, और वो where it is not so recorded. एविडेंस इन चीफ में क्या कह रही है वो कि हाँ, मैंने तो अपनी हर स्टेटमेंट में बोला कि इन तीनों लड़कों ने इस फलानी जगह पे मेरे साथ रेप करा, मगर एक्चुअली में 164 में एक और स्टेटमेंट थी, उसमें बोली थी कि मैं नहीं जानती किसने रेप किया, एक में शहर अलग था, एक में बंदा अलग था, तीनों में कॉन्ट्राडिक्टरी स्टेटमेंट्स थी। एविडेंस इन चीफ में गैंग रेप बन गया, ठीक है? So there is too much of improvement. Now this contradiction is a very important contradiction. So if I was a stupid lawyer, I would have, or if I did not read the file, I would have actually not confronted her. अब ये कॉन्फ्रंटेशन इसकी टेस्टिमनी को शेक कर देती है, that she is not a reliable witness. तो इस पॉइंट पे मेरे को इतनी तसल्ली हो गई एज अ डिफेंस लॉयर कि look, if there is no other evidence, if there is no DNA which is going to match, if there is no eyewitnesses to the scene, if there is no recording, if there is no any other corroborative evidence to her statement, I'm going to get an acquittal based on her statements. We move further. वैसे ही अच्छा, अब उससे पूछा हमने कि अच्छा, आपने क्या होली खेली थी? तो उसने बोला हाँ, she agreed that she played होली। अच्छा, क्या आप यहाँ से यहाँ आपने कभी चिल्लाने की कोशिश करी? तो वो बोली कि नहीं, मैं कभी नहीं चिल्लाई। तो इससे हम क्या बताने की कोशिश कर रहे हैं कि look, she knew what she was doing, she was all over the place, she was playing होली in public, तो वो कैप्टिविटी में नहीं थी, है ना? And her claim that she was sold to different men every day, this could only happen if she was actually a professional prostitute. I will not sell my captive victim to various men on different dates, because वो तो किसी को भी बहला फुसला के वहां से भाग सकती है ना? तो she was not a professional prostitute. It is improbable. अब प्रोसिक्यूशन ने जो केस बनाया है, प्रोसिक्यूशन ने केस बनाया है कि इसका एक बॉयफ्रेंड था, वो उसको भगा के ले गया, इन फैमिली की साजिश थी, एंड सो ऑन एंड सो फोर्थ। तो देयर आर टू मेनी वर्जन्स नाउ। अब पूरे केस की इतनी खिचड़ी पक गई है कि ना तो प्रोसिक्यूशन रिलायबल है, ना प्रोसिक्यूटर रिलायबल है। सो दिस इज व्हाट हैज हैपेंड। So now, as a defense lawyer, your only motive is to study your file in depth. You need to have a comparative chart of all the contradictory statements. You need to have comparative chart or a bundle of all the statements, previous versions. उसने किसी दूसरे कोर्ट केस में कुछ कह रखा है, उसने किसी पुलिस की कंप्लेंट में कुछ कह रखा है, उसने सोशल मीडिया पे कुछ कह रखा है, सब कुछ इकट्ठा करके जाएंगे आप, खाली हाथ नहीं जाएंगे। तो जब इतना मटेरियल आप इकट्ठा कर, उसको नहीं पता 65B ऑफ एविडेंस एक्ट क्या है, उसको नहीं पता कि अगर मैंने इसको मना कर दिया तो ये खत्म हो जाएगा एविडेंस। ये सिर्फ लॉयर को पता है और स्मार्ट लॉयर्स को पता है, डम लॉयर्स को भी नहीं पता। तो आप एक शॉट लेंगे, आप तीर मारेंगे कि whatever evidence, whatever diaries you have, so as Mr. Rishipal Singh said कि वो डायरी एडमिट हो गई। तो अगर किसी ने कुछ लिखा है, कोई स्टेटमेंट दी है, इंस्टाग्राम पे डालिए, फेसबुक पे डालिए, कहीं पे भी डालिए, आप उसका भी स्क्रीनशॉट ले जाके उसको कन्फ्रंट कर दो। अगर मैं उसको कन्फ्रंट नहीं कर रहा हूं तो मेरे लिए बहुत डिफिकल्ट होगा उसको बाद में एविडेंस में लाना, और अगर मैं उसको बाद में एविडेंस पे लेके भी आ रहा हूं तो जज इज नॉट गोइंग टू सीरियसली कंसिडर दैट एविडेंस। Judge is only going to consider that evidence if I've confronted that piece of document. That happens in the real practice, and very few lawyers admit documents at the stage of cross-examination for the opposite. वो बोलते हैं कि अभी अपने पत्ते नहीं खोलने, अभी अपने पत्ते नहीं खोलने, अपने सारे पत्ते। ये बहुत बहुत इंपॉर्टेंट स्टेज होती है। डिफेंस एविडेंस की कम वैल्यू होती है, ये प्रोसिक्यूशन एविडेंस की बहुत इंपॉर्टेंट स्टेज होती है। जितना एडमिट करा दोगे उतना फायदा है। नहीं एडमिट हुआ तो यू ऑलवेज हैव अपॉर्चुनिटी टू सबमिट अ 65B later on along with your evidence. So this is the way the cross examination is done. Acha, the last point I'll touch, I know it's getting late, the last point I'm going to touch is suggestions. जो suggestions होती हैं, आप यहाँ पे देखेंगे, it is incorrect to suggest that I never met Jay at any point of time nor I know him personally. ठीक है? तो अब मैं क्या prosecution को suggest कर रहा हूँ as a defense कि I don't even know this guy. ना तो मेरा कभी इसके साथ affair था, ना मैं इसको जानती थी, और कुछ नहीं लेना। Then it is incorrect to suggest that his name was told to me later by my parents. क्योंकि मेरे पेरेंट्स ने डिसाइड किया कि अच्छा इन पड़ोसियों को फंसाना है, 8-10 लाख रुपए हमको मिल जाएंगे पॉक्सो के केस में फंसा के, और तुम फंसा दो। इतना पैसा तो मैं 5 साल में भी नहीं कमा सकता। इट्स अ वेरी गोल्डन अपॉर्चुनिटी फॉर मी, इट्स बीन फेड इन माय माइंड बाय द पुलिस कि हम 10 लाख रुपए मांगेंगे इनको फंसा के। ठीक है, अब कई बारी ये लक काम कर जाता है, कई बारी लक काम नहीं करता, बिकॉज मोस्टली दीज पॉक्सो केसेस हैपन इन अ वेरी people living in slums or poor socio-economic status. So, but everybody wants to have their pie from the cake. तो अभी क्या है कि जो suggestions की value है, what is the difference between the civil case and the criminal cases? Civil case में आप reply file करते हैं, जिसको आप WS कहते हैं, उसमें आप deny करते हो सब कुछ। Either you agree or you disagree to whatever the pleadings the plaintiff made. But in criminal case, there is no concept of reply. आप पूरी CRPC छान मारेंगे, आपको reply word या WS नहीं मिलेगा। ठीक है? The evidence in affidavit, it's a very recent phenomena, and only the quasi-criminal cases entertain it, which is like NI Act, DV Act, CRPC 125, so on and so forth. क्योंकि इसमें ये क्वासी क्रिमिनल नेचर के हैं, these are very civil oriented cases, तो इसमें रिप्लाई फाइल होता है। बट क्रिमिनल केसेस में कोई रिप्लाई का कॉन्सेप्ट नहीं है। द बर्डन टू प्रूव योर केस इज मेजरली ऑन प्रोसिक्यूशन। नाउ whatever the funda of getting the suggestions correct is, you just scrutinize line by line the evidence in chief. अब आप evidence in chief में जाते हैं, I'll just take you back to evidence in chief here. हाँ, अब देखिए, I have studied up to 2nd class. We are 3 brothers, sister, blah blah blah. इससे मेरे को कुछ लेना देना नहीं है ना? Even if it is true, I don't care. So what I care is, all the people gave me beatings and pressurized to marry S, otherwise they will kill my parents. तो मैं क्या करूंगा? While I am closing my cross examination, I am going to इनको suggestions देना कहते हैं, मैं जल्दी जल्दी लिखवा दूंगा कि it is incorrect to suggest that A, B, C, D did not give me any beatings and pressurize me to marry S. This is all I need to write. तो incorrect to suggest का मतलब है कि मैं उसको suggest कर रहा हूँ कि जो तुम बोल रहे हो वो झूठ है, ऐसा नहीं हुआ, मैं उसको deny कर रहा हूँ. उसके बाद it is incorrect to suggest that accused took me to dash stand. तो मैं इसको उसमें बोल सकता हूँ कि it is incorrect to suggest that I went to bus stand on my own. So this is the suggestion I am putting. मैं बोल रहा हूँ तू अकेले गई है, मैं इस चीज को डिनाई कर रहा हूँ कि तू मेरे क्लाइंट के साथ गई है. ठीक है, फिर मैं लिखूंगा कि we stayed in a hotel for 1.5 days, blah blah blah. तो मैं बोलूंगा कि it is incorrect to suggest that accused person did not stay with me in the hotel and I stayed there alone. तो मैं क्या take away कर रहा हूँ from the entire evidence in chief that I am suggesting to you that you were there in the hotel. I agree to that fact. I don't care that you were in the hotel or not. But all I care is that my client was not with you in the hotel. ठीक है, ये suggestions का concept होता है. You might not understand it at one go. It takes time, but just think like that. आपने evidence in chief को line by line लेना है. आपको देखना है कि आपको क्या hurt कर रहा है और आपको क्या hurt नहीं कर रहा. अगर वो ये line बोली है कि accused जो है मेरे साथ होटल में था और आपने इसको डिनायल में नहीं लिया या सजेशन में इसको नहीं लिया, तो आप इसको एडमिट कर बैठे हो. Courts are not going to take a very serious stance on it, but to be on safer side, put it in suggestion. और एंड में लाइन लिख देते हैं आप that it is incorrect to suggest that I am deposing falsely. So that basically circumvents your entire evidence in chief that I am deposing falsely in the evidence in chief. ठीक है, it protects you, but as a habit you should specifically deny the points which are going to hurt you. कि आप इस point पे present थे, आपने ये किया. It is incorrect to suggest that I have been raped and I am making up the story because police told me to do so, or I am making up the story because my father told me to do so, or I'm making story because I've been pressurized by my parents. तो आप कुछ ना कुछ इसको बोलते हैं जज के दिमाग में डाउट कास्ट करना. तो अगर आप सेकंड और थर्ड सिनेरियो नहीं प्रेजेंट कर सकते कोर्ट के सामने, दैट मींस यू हैव अ वीक केस. तो आपको सारे के सारे एविडेंस इन चीफ क्रॉस में से स्टोरी को उधर ले जाना है जिधर आप ले जाना चाह रहे हो. अब वो एज अ डिफेंस लॉयर आपको देखना है कि हाउ मच इट सपोर्ट्स और hurts your case. So if it is if the prosecutrix is more than 18 years old and there is an evidence that okay they have you will not be able to defend the point that sexual intercourse has not happened, take your case towards consensual sex or a relationship. But if it is a minor, do not do that, because intercourse with a minor is consensual, non-consensual, doesn't matter. You'll be behind the bars. Do not agree. Okay? तो आपका defense strategy क्या रहेगा कि this minor is not a reliable witness. There is no DNA which is matching. There is no external witness to corroborate the story. So he can't be convicted. But अगर आपकी माइनर की 164 की स्टेटमेंट, लीगल एड की स्टेटमेंट, CWC की स्टेटमेंट, एविडेंस चीफ की स्टेटमेंट में कोई वेरिएशंस नहीं है, तो आप गए काम से. अब क्यों होती हैं? what works in the favor of a man is because 98% of these cases they are love affairs. So जो प्रोसिक्यूट्रिक्स होती है वो कंफ्यूज होती है कि कभी वो कुछ बोलती है पेरेंट्स के सामने, पुलिस के सामने कुछ बोलती है, मैजिस्ट्रेट के सामने कुछ बोलती है, जब तक कोर्ट के सामने केस आता है तब तक वो और कोई वर्जन बोलती है. ठीक है, किन्हीं केसेस में तो हॉस्टाइल करा दिया जाता है उनको, पार्टीज में सेटलमेंट लेन देन हो चुका होता है, किन केसेस में लेन देन नहीं होता. तो that's where your lawyer skills are going to come into the picture and you're going to break her testimony. तो जिन केसेस में लेन देन नहीं हुआ और वकील साहब फाइल नहीं पढ़ के आए, अपना होमवर्क नहीं करके आए, तो वो बच्चा गया 20 साल के लिए. तो it's very important. So I think this is what I had to say about how evidence in chief and cross examination is conducted in a heinous offense. I was mostly sticking around to the POCSO and rape case. If given an opportunity, I might take a different kind of a case to explain you that जहाँ पे expert witnesses की value होती है. जैसे अगर murder case है, तो इंजरी कैसे हुई, वहां पे आप बैलिस्टिक एक्सपर्ट को बुलाएंगे, वहां पे आप डॉक्टर्स को बुलाएंगे, पोस्टमार्टम रिपोर्ट में आई विटनेस ने क्या देखा. छोटा सा एग्जांपल बताता हूँ. आई विटनेस ने डंडों से और पत्थरों से मारते हुए देखा, पोस्टमार्टम रिपोर्ट में किसी डिफरेंट प्रकार की इंजरी आ रही है. ठीक है. So that's where the technical expertise comes into the play. You're going to cast doubts in the court कि look, eyewitness cannot be believed because ये इंजरी डंडे से नहीं हो सकती. डंडे से अंदरूनी चोट हो सकती है, किसी का स्कल नहीं फ्रैक्चर हो सकता. समझ रहे हो? स्कल फ्रैक्चर करने के लिए आपको हथौड़ा चाहिए या बहुत बड़ा सीमेंट का ब्लॉक चाहिए. तो you're casting a doubt in the judge's mind. Look, this can't happen. You'll call a lot of experts. A second scenario would be पुलिस ने चाकू रिकवर किया. ठीक है. पोस्टमार्टम रिपोर्ट क्या बोल रही है कि जो इंजरी हुई है, जो स्टैब हुआ है, वो 1 सेंटीमीटर की उसकी विड्थ है और डेप्थ है उसकी, सॉरी नॉट 1 सेंटीमीटर, हाफ अ सेंटीमीटर, और जो उसकी डेप्थ है वो 3 या 4 सेंटीमीटर है. एंड दिस इज कंसिस्टेंट विद द इंटायर पोस्टमार्टम रिपोर्ट. सो जितनी जगह भी घोपा गया है उतनी जगह आधे सेंटीमीटर का छेद हुआ है, बट अंदर तक वो वुंड पंचर किया है. एंड दैट विल ओनली हैपन इफ it punches the vital organs like heart, lungs, so on and so forth. Now, what the recovery was done by the police, because they have to show a weapon, they recovered some damn चक्कू जिसकी टिप आधे सेंटीमीटर की है, बट जब आप थोड़ा सा उसको अंदर ले जाएंगे तो वो चौड़ा होता जाता है. अब वो चौड़ा हो रहा है, तो that means you're going to create a picture कि look, if this particular knife had actually penetrated my chest, the incised wound should have been at least 2 centimeters or 3 centimeters. It cannot restrict itself to half a centimeter. इतनी डेप्थ के हिसाब से. तो ये मर्डर वेपन हो ही नहीं सकता. अब मर्डर वेपन नहीं रिकवर. So you're going to cast the doubt on the ocular version and the medical version. में डिस्क्रिपेंसी आ गई. समझ रहे हैं बात? तो बहुत सारे फैक्टर्स होते हैं. तो इन केसेस में मेडिको लीगल एक्सपर्टीज, so on and so forth, comes into the picture, and that's how you're going to cast the doubt on the case. They're very interesting cases, but that's why it's very important for you to read the charge sheet and scrutinize the charge sheet completely, so that you can help your client. I think I'll wrap up here, and I hope I was little informative, and if someone has question I can answer.
Thank you so much, sir. You were super informative, and I'm so sorry I had to squeeze your time so much. I could see आप काफी चीजें बताना चाहते थे, but you were leaving a lot and you were cutting to the chase.
No, that's fine. अब इसको बंद कैसे करूं मैं?
सर वो ऊपर आ रहा होगा ना, stop
sharing. अच्छा.
हाँ. So
okay.
I know it's time and इतने सारे लोग रुके हैं, तो आप इसीलिए रुके हो because you were finding it interesting and you have questions. So if you have questions और questions पूछने की जान बाकी है, तो you can ask questions. And sir, अगर आप आंसर कर सको तो I'll leave it up.
अगर मेरी capacity में हुआ तो जरूर आंसर.
So yeah, questions guys. I saw Anju raising hand. Anybody else? Anju, you can go ahead.
Okay, hi. I wanted to ask you about one thing which I've been very, very curious about since a very long time. How important is external factors in a criminal case. Now, I'm referring especially to, for example, Nupur Talwar versus, Union of India. In that particular case, when I was following it, what I realized was that there was a trend in which everybody was talking about honor killing. And suddenly this was automatically put into the same box, wherein I felt a lot was dependent on the sensibilities of the police officers and anybody and everybody who was investigating that case, wherein nobody really assessed the mindset of a certain class of society. Now here, when we talked about Arushi did not conform to that typical honor killing kind of a family background. And I felt that, for example, certain questions when I was following that case were being related to that what we are doing, spending night, in at your friend's place. Now, those kind of things could be very common in a certain strata of society. But to the mind and to the sensibilities of the investigation officer, that did not fit. And that automatically connected with having a very shady lifestyle. So how important is that? And is there a person who actually does these analysis?
Very good question, Anju, and it's actually the bad part of the whole system is most of the people see India as a country has a lot of people coming from different socioeconomic backgrounds, right? But police per se and the majority of the lawyer community who are actually involved in criminal law, they technically come from backgrounds which are not very intellectual. All right, so there are very few people. Police, of course, so they've been trained mostly on the physical area. So when you cross-examine them or when they are actually trying to understand the matter, their purpose is to get money out of the case. Okay, they don't care whose life is at stake, what is going to happen. For them, it's a jackpot. Crime has happened, the party seems rich, you're going to get money. ठीक है? अब चलो गरीब भी है तो भी वो उनको पैसा कमाना है किसी तरह से कि चलो 1-1.5 लाख रुपए तो मिल ही जाएगा इस पॉक्सो केस से, और अगर हम इसको इम्प्लीकेट कर लेते हैं तो मर्डर केस में हम चार्जशीट भी करेंगे तो हमको पैसे मिल जाएंगे. So there's a lot of money which exchange hands in a criminal trial. And high courts and supreme courts, see, it's a very it's a very unfortunate thing. You cannot go and quash a rape case if the parties compromise. You cannot go and quash a POXO case if parties compromise. Left, right, and center, compromise happens, money exchange hands, and the witness become hostile. So something which cannot be done through proper channel, it is done through illegal channel. ठीक है? अब going back to your socio-economic concept, जब मैं आपको एग्जाम्पल एक लॉयर अगर किसी पर्टिकुलर बैकग्राउंड से आ रहा है, उसके घर में घूंघट रखा जाता है या उसके घर में शॉर्ट ड्रेस पहनना उसकी अंडरस्टैंडिंग के हिसाब से बुरा व्यवहार है या बुरा चरित्र है, अब उसको अगर एक रिच क्लाइंट मिल जाता है, फॉर इंस्टेंस आई एम नॉट टॉकिंग अबाउट दिल्ली एंड बॉम्बे, आई एम टॉकिंग अबाउट गुरुग्राम, फरीदाबाद और नोएडा, वेयर यू डेफिनेटली हैव एन एलीट, बट आपके पास क्या है, यू आर नॉट गोइंग टू call a super premium lawyer from Delhi to argue a case in a suburban town. You're only going to go to district court and find a lawyer, right? अब आप उस lawyer को, you might be very intellectual, you might be a corporate person, so on and so forth, but आपके ऊपर कोई case आ गया, अब lawyer को जाके बोलोगे, अच्छा, he's the best criminal lawyer in the town. अब he might be coming from a village, ठीक है? अब आप जब उसको facts बताओगे तो वही facts लिखेगा जो उसका इंटेलेक्ट अलाउ करता है. वो बोलेगा कि नहीं इसी बात से जज साहब मानेंगे. आप इसको ऐसा लिखो कि ये लड़की चरित्रहीन थी, या आप इसको ऐसा लिखो, मैं आपको एग्जांपल बताता हूँ. मेरे एक ड्राफ्ट आया कस्टडी केस में, कि this girl वाइफ जो है वो छोटी ड्रेसेस पहनती है, वाइफ जो है वो शराब पीती है, वाइफ जो है वो ये करती है. Client said, look, this is my culture. I don't care अगर वो छोटी ड्रेस पहनती है और वो शराब पीती है. I allow my wife to drink alcohol. And tomorrow this question is going to be confronted that did you disagree, or this question was actually confronted कि look, your sister is also drinking alcohol. Your mother is also drinking alcohol. Then why are you objecting your wife to be drinking alcohol and she's not a good mother? You understand this? And this client had no answer. All he could say is, look, I don't know why my lawyer wrote it. मेरे को तो उस टाइम समझ ही नहीं थी. मेरे वकील साहब ने मुझे बोला कि अब लिख दो ऐसा, और मैंने लिख दिया. Because a lawyer will not be actually asking me or how do you say, analyzing my lifestyle, because he himself doesn't know that lifestyle. आप तो एक को उसी ocular vision से देखोगे ना जिसको आप जानते हो, है ना. आपकी हैसियत है 50 रुपए की चाय पीने की, और the moment you enter a 5-star hotel and you have to spend 700 on a cup of tea, आप बोलोगे इतने पैसे फूक दिए इसने, पागल है क्या तू, right? नहीं, this is not possible. So how will you deal with it? It's always going to be there. So that's why when we say it's segment target positioning, now the problem comes is the police force comes from that background. अब आप बिलियनेयर भी हो तो आपको आपका क्राइम तो एक इन्वेस्टिगेटिंग ऑफिसर ही हैंडल करेगा जो एक सर्टेन बैकग्राउंड से आ रहा है इंडिया में.
Precisely my concern, because here actually even if your advocate may be from a certain kind of a background, the biggest challenge is the person who is investigating the case. Basis that the cognizance of the magistrate or anybody and everything kind of depends on that, right?
अब आरुषि के केस में why the eventual acquittal happened, now of course the courts were tired, all the senior advocates are involved and everything. Eventual acquittal happened because the prosecution had actually screwed the case. State ने इतने सारे lapses थे investigation में, है ना. वो evidences नहीं collect हुए थे. People were allowed to.
The whole place was tampered with. Nothing was there to even begin with. But
so
nobody.
You don't know what happened at that stage. We only get to know through the documentaries and web series, but we actually don't know what had happened in those 48 hours. All the evidence, हमको तो दूर से ही दिखता है ना. हो सकता है initial stage पे सारा evidence गायब कर लिया गया हो या tamper कर लिया गया हो. और you can only convict somebody based on, most of the acquittals happen because the police did not investigate the matter properly. And precisely this is what had happened in this case. Police did not investigate the matter properly. So initial conviction happened, then acquittal happened, so on and so forth. 90% cases बर्बाद ही इसलिए होते हैं कि police did not investigate the matter properly.
But my question here would be in that case is that, do these points of arguments ever get raised in front of a judge? That, sir, you need to take into account that the person who is investigating the case comes from a certain background wherein his sensibilities may not be in sync with what really transpired there.
See, there is a provision to help that. Now you're dealing more on the emotional side. If we look at the technicalities of
actually more to do with not really emotional but psychology.
I agree that, because psychology does not play any role in the investigative part.
Precisely.
Now, what matters is, अगर आपकी investigation ठीक से नहीं हो रही है तो आप 156(3) की application लगाएंगे, you might already have a good lawyer. ठीक है? Your good lawyer will go and file in the magistrate court कि look, I'm filing this 156(3), investigation needs to happen this way. Police is not getting the call records, they're not sending the things for the FSL, so on and so forth. वो भी नहीं होता है, then you approach the High Court for the transfer of investigating agency. You either get the case transferred to CBI, CIA, so on and so forth, right? वो आप तभी करोगे ना जब आपकी जेब में पैसा होगा और आप इतने इंटेलिजेंट हो. बट अगर आप एक गरीब आदमी हो तब तो आप पुलिस के सामने हाथ जोड़ के खड़े रहोगे, वो आपकी शायद FIR भी ना रजिस्टर करे. This is the problem. This is the problem. It's all money. 90% accused in jail in POCSO cases are people coming from poor socio-economic background. Police by protocol should have done their age assessment before filing a charge sheet. to get the benefit of Juvenile Justice Act. They don't do it. Lawyers don't file for the bone ossification application. Why? Because the moment that this minor is declared minor, nobody gets the money. किसी को भी नहीं मिलेगा ना पैसा. पुलिस का भी नुकसान हो रहा है, सबका नुकसान हो रहा है in the process. It's a very bad situation. You can't really help it, but yes, you can fight as much as you want. So, yeah.
Anybody else? Any question?
Hi, sir. I have a question, sir.
You need
Sir,
to put your
during
camera on, otherwise
investigation-
I won't answer.
Yes, sir. Yes, sir.
Yes, Akshay.
Sir, during investigation, sir, as you told that the witness cannot go out of the court, right, sir?
During
Sir,
investigation.
no, chief examination, sir.
Okay.
Right, sir. Sir, as you said, sir, there is some person who passes some important paper, right, and he passes on to the witness. And as you told, sir, that the witness, we can object in the court that the witness cannot go outside the court, right? And to the witness. This is an important thing is mentioned there, sir. So how can we object that, sir?
आपके विटनेस को कोई पेपर मिल गया हाथ में और उसने वो पढ़ लिया.
Yes, sir. Sir, वो बाहर से दिया किसी ने.
बाहर से आके दे दिया कि पढ़ लो.
Yes,
हाँ,
sir.
तो जज साहब को शिकायत लगाओगे ना.
नहीं सर, वो that's okay, sir. सर वो कोई important था point. So उसके
नहीं, this can't happen. Nobody can come and
important contradiction वगैरह आ गई.
nobody can come and speak to the witness at the time of cross-examination. No paper passing business, no mobile phones, nothing can happen. In fact,
Okay, sir, okay.
आपके lawyers जो victim का lawyer है, आप उसको भी side में दूर खड़ा करा सकते हो.
Okay, sir. And sir, one more question, sir. Yes, sir, police unnecessarily harass करती है sir accused को. मतलब कहते हैं if even if the prima facie case is not made out, तो इसके against हम लोग क्या steps वगैरह ले सकते हैं, मतलब क्या remedies वगैरह ले सकते हैं?
बहुत सारी रेमेडीज होती हैं. अगर सबसे पहली तो ये रेमेडी होती है कि जब एक्यूज को पेश करते हैं मैजिस्ट्रेट के सामने, तो वो आपसे पुलिस कस्टडी मांगते हैं, ठीक है, रिमांड मांगते हैं. तो अगर केस हीनियस ऑफेंस है, जनरली अ सीरियस लॉयर विल नॉट अप्लाई फॉर बेल एट दैट स्टेज. तो आप जुडिशियल रिमांड मांगोगे, जुडिशियल कस्टडी मांगोगे. जुडिशियल कस्टडी में सेफ, जेल का खाना खाना पड़ेगा, बात अलग है, बट पुलिस के टॉर्चर से बच जाएगा. तो जब इनिशियल स्टेज पे जब accused is presented in the front of a magistrate within first 24 hours as per 167 CrPC, they're going to bring the remand papers, remand application. उसमें उनका एक वो होता है, एक परफॉर्मा बना होता है, जिस परफॉर्मे को जज पढ़ता है, ठीक है, कि क्यों चाहिए इनको पुलिस कस्टडी. So if they're going to ask for 3 days, then अगर the magistrate thinks prima facie कि yes, I should hand over this person, ये रिकवरी नहीं हुई, वो रिकवरी नहीं हुई, so on and so forth, तो उनको 1 दिन की कस्टडी दे देंगे या 2 दिन की कस्टडी दे देंगे. उसके बाद वो दोबारा अगर मांगेंगे तो मना कर देंगे. और जो डिफेंस काउंसिल है आपके एक्यूज का, वो भी खड़ा होकर बोलेंगे कि योर ऑनर, देयर इज नो नीड फॉर एनी मोर पुलिस कस्टडी, जेसी में भेजिए. फिर 15-15 दिन की जेसी मिलती रहेगी. अगर आपके पास स्ट्रॉन्ग डिफेंस है उसको बेल दिलाने का, तो आप फिर बेल दिला देंगे जब तक चार्जशीट नहीं फाइल होती है. अब जो ऑफेंसेस होते हैं अप टू 3 years, 7 years तक अरेस्ट नहीं कर सकती पुलिस. उसमें आपको 41A का नोटिस देना पड़ेगा. तो अगर पुलिस ने अब रिसेंटली फाइल्ड अ कंटेम्प्ट इन पंजाब एंड हरियाणा हाई कोर्ट व्हिच वाज एंटरटेन्ड इन पंजाब एंड हरियाणा हाई कोर्ट फॉर द फर्स्ट टाइम. अरनेश कुमार की जो सुप्रीम कोर्ट की गाइडलाइंस है. So in a custody case, the man had उसने एक पर्टिकुलर प्लेस पे अपने बच्चे से मिलता था, तो वाइफ ने पुलिस के साथ मिलके उसके अगेंस्ट जुवेनाइल जस्टिस एक्ट में एफआईआर दर्ज करा दी. और पुलिस ने विदाउट सर्विंग 41A का नोटिस, दे अरेस्टेड दिस मैन, दे केप्ट हिम इन कैप्टिविटी, बेल हैपेंड ऑन द सेम डे, सो ऑन एंड सो फोर्थ. तो हमने कंटेम्प्ट फाइल किया हाई कोर्ट में बोल के कि लुक, दिस ऑफेंस वाज ओनली 3 years, दे शुड हैव एक्चुअली सर्व्ड हिम विद अ 41A नोटिस एज पर Ranesh Kumar and kindly take the cognizance of this contempt. So the high court issued notice to all the 3 police officers who had actually made this illegal arrest. तो अरनेश कुमार की अगर आप जजमेंट पढ़ेंगे तो 7 years तक you're well protected. अगर पुलिस कुछ भी मालाफाइडीज कर रही है तो आप कंटेम्प्ट फाइल करो, फिर वो चुप हो जाते हैं, उनकी नौकरी पे आ जाती है. दूसरा क्या है, ओवर 7 years अगर कुछ उल्टी सीधी हरकत होती है तो फिर आप 482 में जा सकते हैं. बहुत सारी रेमेडीज होती हैं. you'll understand as and when you'll grow in criminal practice की how do you protect your accused at various stages. So yeah.
Okay, sir. Thank you.
You're welcome.
Right. Anybody else? Any question? Divyam, you have a question?
Hello. Hello. Good evening, sir. Firstly, I would like to thank you for this lovely session, sir. And so my question is, so I was working in a case, usme basically the guy, sir, the guy and the girl both were in love, and उन्होंने फिर उसके बाद, hello, am I audible?
बोलिए.
I think I have some network issues.
No, you're very much audible. Continue, please.
Okay. The boy and the girl, they were both in love with each other, and they both decided to run away. They both were minors, and they both decided कि चलो साथ में भाग जाते हैं. And while during that course of period, while running away, they both got caught. And लड़के वाले की family, they were very poor. And लड़के वाले obviously they were very rich as the story is. And फिर उसके बाद वो लड़की वालों ने बहुत पैसा दिया पुलिस वालों को, पॉक्सो की केस में उसको अंडर कर दिया. एंड नाउ द थिंग इज वो बंदा 3 months से जेल में है, वो निकल नहीं पा रहा है, और उसके बाद लॉयर के लिए पैसे भी नहीं है. उन्होंने सामने वाले ने बहुत पैसा दे के रखा है पुलिस वालों को. वी कांट डू एनीथिंग.
कौन सी सिटी का केस है?
सॉरी सर,
कौन सी सिटी का केस है?
सर इट्स अ वेरी स्मॉल प्लेस इन वेस्ट बंगाल, पुरुलिया.
Okay. This is an
Yes, sir.
ongoing case.
यस सर.
Okay. लड़का स्कूल गया है कभी?
लड़का स्कूल तो कभी नहीं गया. वो बहुत ही पुअर फैमिली से, इज अ साइकिल रिपेयरिंग शॉप में काम करने वाला गाय.
अच्छा, तो आप ऐसा करें, are you going to handle this case?
No, I'm not going to handle. I'm just an intern, but I've heard this case, and their family just talked to me कि what can we do and what remedies can we take. So I didn't
आप एक
had
काम
much.
करो, आप ना एक सेक्शन 94 ऑफ जुवेनाइल जस्टिस एक्ट में उसके लिए बोन ऑसिफिकेशन की एप्लीकेशन लगाओ.
Okay, section 90. I'll just look it up.
ठीक है, बोन ऑसिफिकेशन टेस्ट होता है, और if this guy is declared juvenile, this case will be transferred to juvenile justice board. और उसके बाद वो सेक्शन 12 में उसकी डिफॉल्ट बेल होती है.
Okay.
ठीक है, that's a step you need to take. So if you really want to help this guy, you either travel there or you do a legal aid council in local.
Yes, I was thinking to do that, sir. Yes.
हाँ, तो अगर आप एक लोकल काउंसिल अरेंज कर लेते हो तो उसके बाद we can draft this application. Just get hold of the charge sheet at least. We can draft this application. We can send it to the council. Then the court has to decide. और उसके बाद बोन ऑसिफिकेशन से अगर वो जुवेनाइल डिक्लेयर हो जाता है तो उसको जेजे बोर्ड में ट्रांसफर कर देंगे, वहां से उसको डिफॉल्ट बेल मिल जाएगा. And
okay, and so what
sooner
about
you
this
do it, the
harassment?
better it is. Huh?
Sorry, sir, you were saying something?
I'm saying the sooner you do it, better it is.
Yes, sir. And what about the harassment? He's facing a lot of harassment by the police because उन्होंने सामने वाले पार्टी ने बहुत पैसे
नहीं
दे
तो
रखे
वो तो
because of
जुडिशियल
that.
कस्टडी में होगा ना.
Sorry? No, he's in jail. He's in proper jail.
हाँ, तो harassment by police, you can put an application to get a transfer to a different judicial custody in high court.
Okay.
कौन सी सिटी में है?
So Purulia.
Okay.
It's in West Bengal.
Which year are you in?
Final year.
Purulia is in West Bengal. What you can do is you can file a 482 in Kolkata High Court asking to transfer his judicial custody to a different court because of the harassment he's been met with the local influence. So they can transfer him from a different jail to different jail, and the case can go on there.
And can we ask for compensation regarding this? That he's been suffering for so long, and
No,
he's even
compensation जो होता है victim को होता है, accused को नहीं होता. Plus आपको पहले उसे जेल से बाहर निकालना है. तो या तो आप उसकी बोन ऑसिफिकेशन की एप्लीकेशन लगा के उसको जुवेनाइल डिक्लेयर करा लो, या आप उसकी जुडिशियल कस्टडी ट्रांसफर करा लो. आपको पहले एक लॉयर गेट होल्ड करना पड़ेगा, उसके बाद ये कुछ हो पाएगा.
okay.
I mean, it's a very
Okay.
weak ground that he's being harassed because everybody is being harassed in the jail. So the expeditiously you declare him juvenile, that's the best way to help him.
Okay.
Find a lawyer
sir,
in that city, then we can take it further.
Sure, sir. Sure. Thank you, sir.
आप कहाँ पे रहते हैं?
Sir, I'm from Purulia only, but right now I'm in Delhi, so interning.
So it's your hometown.
Sir, hometown is Purulia. Yes,
So get hold of a local lawyer and then I'll tell you what to do. Draft an application and give it to you.
okay. Okay, sir, I'll do that. Thank you, sir.
No problem.
I think let's wrap it up here. Even if
Yeah.
anybody has questions, we'll take it in the next session. And आपको सर पता ही है, इतनी देर तक आपको रोक के रखा है, तो people had fun, and you have seen the chat box also.
I can only
Everybody
make out with the smile of Mr. Tandon. He's the only person I know.
Right. Thank you so much for spending your time with us, sir. आपका कल केस भी आपने प्रिपेयर करना, मैंने अभी चैट पे देखा.
नहीं, अब तो हमने खाना खाना है और सोना है, सुबह उठ के करेंगे.
सर अब सब
चलिए.
सो.
Thank you, Raghav,
Thank you
for
so much.
having me. Thank you, Mr. Tandon. Thank you, everybody. Good night and see you soon.
Thank you, sir.
Bye.
Thank you, everybody.
Wonderful session, sir. Too
Thank
good.
you, Mr. Tandon. You made my day.
Thank you.
Really, it's a wonderful and informative session. Thank you, sir.
All right. You're welcome.
Sir, it was a very insightful session. Thank you, sir.
Thank you, Akshat. Thank you, Mr. Rati, Maulana, Gopal Singh. Good night, everyone. Bye.
Yeah, nice, sir. Highly obliged.
Thank you, sir.
Thank you.
Super.
I'm going to start blushing now if I'll get so many compliments suddenly.
Thank you so much.
Sir, in short, they're calling you for another session.
Yeah, I understood that.
All right. Good night, everybody. Thank you.
Bye.